Appeal, Actavis Group and others, and ICOS Corporation and other.
My lady, my lords, we were yesterday talking about value judgments, and can I just say this? The value judgments that count are those that go to the question of whether the skilled person ordinarily does something within the claim or not. So a value judgment where they may go off some way which leads to not being in the claim is a relevant one. And there's nothing in Phase 1 or Phase 2A where any question like that arises, and the only value judgment that conceivably is relevant is whether the skilled person proceeds with the Phase 2B studies for their purpose to ascertain the dose response. And the reason I put it like that is because the thing that my learned friend relies upon is the judge's holding that although it's very likely, it's not inevitable, because they may stop on the plateau. And so questions about the MED and how you ascertain that, which my friend went to again in his submissions yesterday, are completely irrelevant to that question. And let me just show you how the point was put in the Court of Appeal. It's a paragraph that my learned friend took you to yesterday. Lord Justice Floyd, para 169 at MS 325. And you see he explains the whole purpose of embarking on routine Phase 2B is to identify the dose response. And the discovery of the plateau, that's what happens when you only test higher, means that you have to test lower.
Sorry, which paragraph are you reading from?
169, towards the bottom of 325. So you discover the plateau by testing higher, and what that means is that you have to test lower, and then you're within the claim.
Could I ask? I mean, I see that's what Lord Justice Floyd says, but that assertion that the whole purpose of embarking on Phase 2B is to identify a dose response curve, that isn't an agreed fact in the Statement of Facts and Issues. And was it a finding of fact by the judge at first instance?
Well, it's the substance of what is in the Statement of Facts and Issues in the paragraph that I showed you, which I say is important, which is where it says the idea is to do that. So it's paragraph 33. So what the judge found, the wording in this, I think, reflects the judge's finding, and that's that the idea of Phase 2B, so I'm MS 117, and that's why yesterday I said to my lady, my lords, this is a very important paragraph. Phase 2B, the range to be tested is chosen to show an effective dose. And that means to show how efficacy changes with dose. The idea is that a higher dose will show a larger clinical effect than the smaller dose. And if you pick doses where you're just on the plateau, my lords, you're not doing that. Exactly, yes. And my recollection is that the paragraph that says multiple doses is known is actually not just there. It's that bit comes from the bit on the facts. At the end of paragraph 327, at the top of 408, which is the idea that if you haven't got what you want the first time round, you do another one. So it's the very last paragraph, sorry, last sentence of 327. And so what in substance is happening, if you look at MS 208, which is our
Which paragraph is that? Page
327, right at the end of 327408, is the very last sentence.
What, multiple dose ranging studies?
Exactly.
In general terms?
Yeah.
Yes.
And so if you go to MS 208, which is our attempt to show in a picture the difference between finding the dose response at all and the MED, what Lord Justice Floyd is contemplating is that you pick doses that are all on that top plateau, the top right-hand side. And of course, when you've done that, you don't know how far away from the dose response you are until you actually move down and find it. And all that paragraph is saying is that that's what you do. You go down, and in order to find the dose response, you inevitably go to 5. Now, my learned friend criticised the word inevitably in that paragraph, but that's an unfair criticism, because what the learned judge is talking about is if you complete the dose response. The idea that you stay on the top plateau, if you complete the dose ranging studies, the idea of staying on the top plateau is not completing it. And so, just standing back, my lady and my lords know that the judge held that it was very obvious to implement Dorgan. That's the finding of the judge reflected in the important paragraph 43 in the agreed statement of facts and issues, which is on MS 121. And the findings about it being very likely but not inevitable are in the judge's judgment at MS 408, paras 327 at the top of the page, and then he explains in 328 and 329 that would lead to 5 milligrams if you did not stay on the plateau. And I think you might have got a flavour of actually the evidence underlying that finding, because you'll have seen it set out in Lord Justice Kitchen's judgment in the Court of Appeal. It gives you a flavour of just how routine this is. If you go to MS 317, you see an important passage of the evidence of my learned friend's expert, Dr. Saoud.
So this is page?
317.
317, thank you.
Sorry.
There's my apologies.
And it's the bottom of the page, and I was cross-examining Dr. Saoud on this very point as to what a skilled person would do if the routine phase 2B tests showed the doses tested were all on the top plateau. And as is often the case in patent litigation, we had real-life results that could be used, not because they're part of the state of the art, but because they're evidence of what the skilled person would routinely see in empirical implementation. And in this case, the patentee had done exactly what we are postulating. Initial phase 2B testing in the range 10 to 100. And if you pick it up at the bottom of MS 317, before the extract, you see the context of the question is explained. It's about a study called LVBG, where all the doses were equally efficacious. So that means on the top plateau. And in the extract, you see this. We know we're on the top plateau for efficacy. We know going lower will reduce side effects. It really is a no-brainer, is it not, Doctor? To go lower? Yes, in this population. And then for good measure, I read him the conclusion to that effect from the report, and he agreed that that's the conclusion that the ordinary skilled man would come to also. That's the top of MS 318. So, my lady, my lords, that is the value judgment. To continue on the road to Rome. Their own expert agreed it was a no-brainer. And the next passage quoted by Lord Justice Kitchen is also illuminating, as he himself says. This is para 142 of his judgment on MS 318. I quizzed him on why he thought Dr. Pullman had done something which was inventive. Now, you may recall that Lilly actually called Dr. Pullman the inventor. I didn't cross-examine him, but they were seeking to put forward an inventor's story. So just as an aside, you might think that it's a bit ironic that they seek to make a point about the Court of Appeal and its approach leading to an investigation as to the process of how the invention was actually made. In fact, they're quite wrong about that, because what the investigation is what the skilled person objectively would do. But nonetheless, it's ironic that they make that criticism. Anyway, I asked Dr. Saud what exactly he considered Dr. Pullman did that was inventive. And you see the answer in the middle of the extract in para 142. And it's this: thinking that a lower dose will need to be tested before the results came out, before the 10 to 100 milligram results. And he confirmed he was referring to the LVBG study, and that what he was saying is thinking to test lower before he saw the results of that study. And he agreed in this passage that they would go lower anyway once they had those results. So just pause there. This illustrates vividly that this is not a technical contribution in any relevant sense. I say in any relevant sense because it is not adding any product or process or anything that the skilled person wouldn't do without invention. It's positively accepting that the skilled person would do it anyway as a result of routinely ascertaining the higher doses are on the plateau. Now, my lady and my lords will see Lord Justice Kitchen's conclusion after that in paragraph 143 goes on and says this is not a many avenues case. It's a case of two lanes in the road to Rome, the possibilities of on-demand or daily regimes, both of which would be addressed in the light of routine work revealing the half-life. That's what makes it suitable for once a day. Both would be addressed and both would very likely lead to the invention. Let me tell you why I say that. The main body of findings in the judgment relate to on-demand studies, and that's the findings that I've showed you a little earlier. But separately, the judge addressed daily dosing, and that's a short section following on, which he held. Let me just give you the references, paragraphs 337 to 341 on MS 409 to 410. My learned friend skipped into it yesterday without drawing attention to the fact that he'd moved to a different section, but he held that this would also be investigated, and for the same reasons the skilled person would find a plateau and the reasons for going lower would be the same. So what I say to my lady and my lords is what these findings amount to are not only arriving at 5 milligrams is an obvious thing to do when you set about implementing Dorgan, but it's by far the most obvious thing to do. It's well within the skilled person's repertoire. And there's never been any suggestion that Dorgan itself is not an enabling disclosure, and that would be surprising if there had been, because Lilly has already enjoyed a monopoly granted pursuant to that document, as I shall show you. If we go to Appendix Part 2, MS 598, this is EPO 0839040. You see the inventor down on the bottom left-hand side, Dorgan.
Can we have the page number again?
I'm sorry, 598.
Thank you.
Inventor is Dorgan, the proprietor is ICOS, and the international publication number, which is the one given in the top panel beside numeral 87. My lord not got it.
It's Appendix Part 2.
Yes, it's a separate paper. It's actually the first document in it. Is that the supplemental bundle? Yes. It's not that one. It might be the one my lord just had. Is that it?
That's Appendix Part 2.
Yeah, that one.
As far as 598.
Oh, that's the MS number.
MS 598. So it's the first page, my lord.
MS 598.
Yes, right at the front. It's the first document.
319 in the hard copy.
Yes, it will.
Right, sorry about the delay, I've got that.
No, it's my fault. It's,
your
it's, it's, but that's the patent, and you see the name Dorgan, as the inventor, bottom left. Just over on the top right, in the top panel, beside it, numeral 87, is the international publication number. That is the Dorgan number, the WO number. I'll give my lady, my lords, the reference. It's MS543. You can check it later, but I'm not going to take time chasing it down now. But of interest to my lady and my lords is a Swiss form claim to the use of tadalafil to make a medicament to treat ED was granted pursuant to this disclosure. Page MS610, claim 3. It's the first one of those two compounds where you pick one in the Swiss claim. So claim 3 on 610 is a Swiss claim. Doesn't have the dosing limitation, but apart from that, that is the Swiss form claim to the use of tadalafil to treat ED. And it's enabled because, although it doesn't address the appropriate dosing, there are routine ways to ascertain dosing. So this monopoly has been enjoyed and, importantly, dedicated to the public after expiry as part of the patent bargain. Yet my friend's case is that just because it's not inevitable that the skilled person doses in the routine way, he can have another patent. And I think my lady and my lords will have worked out that he's not saying he can have it covering the unlikely way. No, he's more ambitious and says he can have a claim covering what the skilled person very likely does if they were following Dorgan anyway.
Testing required to establish the dosage range had not been routine, if it had required some further inventive step, would this claim have been insufficient?
Indeed. If it couldn't be done following the routine steps, it would have been insufficient. And that's when I said there's never been any suggestion it's not enabled. That's really what I meant. And what they're trying to do is to just take back that which the ordinary abled, skilled person is assumed to be able to do following Dorgan, and he wants to take it back. And I hope that you will have realised that the reason I've drawn attention to cases like Merrill Dow and the explanation that one can know something under different names or by different information is that really that's all that's going on here. What my friend is saying is I found out another piece of information which couldn't be predicted, 5 milligrams. I write it in so I can have actually what is the same thing back. That's the case. Can I move on to a slightly different topic, and that's to be very careful about what actually does and doesn't matter viewing the invention. My lady and my lords will have seen we've put down a marker as to the care that needs to be taken with some of the points that are being advanced by my friend. And I suspect that you won't be surprised to hear me say that the technical contribution being commensurate with the scope of the monopoly means that when you're formulating an inventive concept to judge the patent or any kind of description of the technical advance, it must be something that applies to the whole of the claim. And let me just very briefly show you that in Brugger, which we've been to already, but it's Authorities Bundle 2, MS 1359. So that's tab 13 in that bundle. And under the heading Inventive Concept, so that's about a third of the page down, the first paragraph addresses this, and you can really see it by picking up the end of that paragraph. Sorry, 1359, left-hand side, inventive concept is the heading, and it's that first paragraph, but really the conclusion is the last 3 or 4 lines. What you can't do is pick a narrower subgroup and then seek to apply a description about that to the broader claim. Now, we have, in this case, a Swiss form claim. So the achievement of efficacy to treat ED is a functional feature of the claim. But as I pointed out to my lady and my lords yesterday, it's not limited in any way to daily, i.e. chronic dosing, as opposed to on demand. Nor is there any limitation in the claim about particular levels of side effects. Moreover, when we look, as we will come on to in some detail in due course, to look at the patent and the priority document, they're all about a drug, or in the priority document, a very large class of drugs, said to be an improvement over sildenafil. So side effect comparisons are as against that. And my friends attempt to portray the case as about an invention which is providing a revolutionary daily, i.e. chronic dosing regime, which is an improvement over the 10 and 20 on-demand doses of tadalafil, are in my submission wholly illegitimate. And it's worth noting that in fact the claims of this patent encompassed all those commercial doses until relatively recently, when Lilly threw away 10 and 20 from the claim. So it would be very strange if the invention could have been all about that alleged improvement. But in fact, it's worse than that for Lilly. It's a blatant seeking to rewrite history. They're arguing it protects work that not only is not reported or disclosed in the patent, and certainly not the priority document, but if you stop and think about the timeline, it never could be. What's important is work reported in the patent and the priority document. It is that which is the technical contribution, if any. And can I start on this topic by showing, my lady and my lords, the document that my friend secured permission to appeal with. So that's the first one in the core bundle, tab 1, and the substance of it starts at MS15. But I want to take, my lady and my lords, to section 6 on MS24. And if you go to paras 2 and 3, you see in para 2 it's stated that Lilly invested very significant time and resources to develop an improved daily dosing regime for tadalafil. They explain that following the development of the higher 10 and 20 doses for on-demand use, first approved in November 2002, Lilly then made substantial further investments in developing the daily dosing regime over the course of an additional 5 years. And they give the date for the approval as June 2007. Para 3 goes on to say this improved dosing regime has revolutionised the way ED is treated. They say it provides a normal function day and night and has an added benefit that's not accompanied by unwelcome side effects. The assertion is that this is reached as a direct result of Lilly's investment, and they finish with the statement that the daily dosing regime is 30% of the market. And you see, actually at the beginning of paragraph 2, they had referred back to section 5 as detailing what's summarised here. If we skip back to that, we see those matters are detailed in para 13 to 19. So that's MS 18 and 19. In a section rather flamboyantly entitled Lilly's Voyage of Discovery. It starts at para 11. Para 13 sets the scene by referring to sildenafil, known to most of us by the trademark Viagra, which was approved for use in March 1998. And this para refers to the side effects reported with that drug. You see at para 14 the explanation that the same month that sildenafil was approved, ICOS had completed a proof of principle clinical trial. That's the phase 2A single go, no-go trial. Then para 15 mentions the 2 phase 2B dose ranging studies. The doses included were 10 to 100 and 2 to 25 respectively. These are carried out in 1998. This paragraph showed these showed efficacy at lower doses than was expected, just pausing here, the whole case is in fact about the work mentioned here. In fact, it's worse for my friend because, as we shall see, when we look at the priority document, it doesn't begin to disclose that work anyway. But that's what the whole case should be about. The second one of those studies is the one undertaken before seeing the results of the first, the thing that Dr. Saoud had thought was inventive, doing it then, but a no-brainer once the results of 10 to 100 were seen. But the end of the paragraph doesn't acknowledge that the case is about that. Instead, it portrays the opposite impression. It says clinical work continued on the on-demand doses. Paragraph 16 moves forward to November 2002, when Lilly approved approval on the on-demand doses of 10 and 20. It said in the order of 26 clinical trials covering aspects of pharmacology, drug-drug interactions and the like have been done. And there is further mention of 10 phase 3 clinical trials, all for the on-demand regime, and also mentions that it's been made it's been on the back of in vivo testing in animals. Then paragraph 17, the picture conveyed is that although Lilly has achieved approval for on-demand, it decided to invest in daily dosing, which required clinical studies. And it said there were 3 further phase 3 studies. The next paragraph, paragraph 18, explains there were further 5 years of development, eventually in June 2007, the 2.5 and 5 mg doses being approved. And paragraph 19 states that this daily dosing regime protected by the patent has revolutionised the way ED is treated. And they criticise the result over the page that all this expenditure can't be rewarded. So the suggestion is it's directed to the daily dosing regime, and it actually suggests that the work didn't start till after the on-demand was approved, and it's attempting to protect that work done between 2002 and 2007. Now, of course, this narrative doesn't explain what the state of the art was at different stages, and we know that the use of tadalafil to treat ED was front and centre, that's Dorgan. But at this stage, I just want to make sure you see the ball being slipped between your legs. And I invite you to perhaps ask Mr. Wall why any of this is legitimate. Because the claim isn't limited to daily, as I've told you. But worse, and more starkly than that, is that it's basically suggesting to my lady and my lords that the work that they seek to protect is that between 2002 and 2007. Perhaps you could turn up the agreed chronology at the back of the statement of facts and issues. MS page 133. Very first entry is the priority date. 30th of April, 1999. That is the date when the priority document was filed, and it is agreed that the patent is invalid if it's not entitled to priority. There are other prior publications that come in if it loses priority that my lady and my lords are not concerned with, because it's agreed that it is invalid if it loses that. That is a document, my friend says, contains a clear and unambiguous description of his invention. The patent itself was filed just short of a year later, as is norm. You see that in the second entry, so that's April 2000. Please also note the third entry. The patent was granted on the 15th of October 2003. And while we're on it, you can see the sixth entry was when, that's March 2015, the publication of the amendment. That's when they threw away 20 and 10. So they limited it down from up to 20 down to 5. And that's a central amendment that is possible to make in the EPO now. But I hope my lady and my lords will have spotted the timing problem for my friend. The inventive work said to be deserving of reward was all carried out after the priority date. The whole thrust of this explanation is to suggest that Lilly's deserving of a patent reward for work that it did well after that, and indeed well after the patent was filed. My lady, my lords, patent protection is about inventions disclosed in patents and priority documents. In fact, it's even worse for Lilly because the inventor, the person put forward as being the main protagonist, in fact left Lilly in July 2001. I'm sure it won't be disputed, but if necessary we can provide my lady and my lords with the CV that was attached to the back of his statement. It's not in the bundles because we haven't been looking at his evidence, but that's what it says. And just a marker on this point, this is a major part of how we say there is a link or attention to the issue with priority. Because the way this invention is characterised in this court is absolutely fatal for my friends on priority. The priority document is not about all of the revolutionary improved dosing of 2 and 5 over 10 to 20 of tadalafil. Now, I've been showing you the document that actually secured permission to appeal to this court, but you'll see substantially the same presentation of facts in their written case. This is paras 48 through to 56 on MS 148 and 149. I'm going to move on and address the obviousness case law, if I may, but before I do so, I just want to pause and explain a few of the points of principle or the use of language that may crop up. The first point I want to make to my lady and my lords is that it's important in my submission to have regard not only to the wide variety of circumstances that may arise in terms of technology and invention. There's obviously a plethora of technical circumstances that may arise under patent law, but there are different types of scenario that you can identify in other ways. And the first point I want to identify is that there's a difference of some substance between a situation where the step that one's concerned with is making a change to a prior proposal, say to make an improvement. That on the one hand, and the other is just considering how a skilled person would go about implementing a proposal because the level of detail is not addressed in the proposal. So they're two different things. One is specifically deciding to change something, and the other is just, well, they haven't told me precisely how to do that, but I know. We may be applying the law of obviousness to both kinds of cases, and all I'm saying to my lady and my lords is not that there's a precise demarcation. I don't suggest that for a minute, but you've just got to have one eye on what it is that you're looking at when you look in the cases. Are we talking about an improvement case, or are we talking about filling in the detail? And I think my lady and my lords will understand that I say in this case we're just a filling in the detail on Dorgan. The next point I want to draw attention to, it's something that my lady and my lords have seen in Lord Justice Kitchen's judgment about the many avenues or a single avenue. I just want to explain what we're talking about when we talk about that. How does one decide between a single avenue of inquiry or multiple avenues? The essence of it in my submission is whether or not the information that you see or ascertain affects what you do next. Let me explain what I mean by that. If you have different avenues or lines of inquiry, you will have different lines of inquiry if each step or thing that you're considering is independent. And my friend has given a very good example of that in his finding antibiotic effects by digging up soil samples. They're each independent tests. You dig up a soil sample, and each bucket is a stab at finding the needle in the haystack, and you're either lucky or not. And you don't do something different with the second bucket depending on what you saw in the first bucket. They all go in, and they're independent lines of inquiry. And that is empirical research, but it's not empirical implementation of the kind that I'm describing, because that's much more like a single line of inquiry, where what one does is determined by what you've just done. And an engineer would refer to it as a feedback loop, but all I mean by that is that it's a single endeavour, and even though you can see individual stages, the information that you ascertain at one stage determines what you do next. And I'm trying to think of a way to illustrate that in a homely way. When you go to the opticians for an eye test, the opticians puts those frames on you and takes out a big rack of lenses and adds one and asks you whether you can read the letters, and then adds another one, and you may have a combination of 2 or 3 in at once. And the way they move is iteratively, in light of whether you say it's a bit better or a bit worse. That is a single line of inquiry. Even though there are a plurality of stages, the point is to find the prescription that gives you the best vision. And the lenses are added or swapped in or out in an iterative process. And one can't look at the tray of lenses at the beginning and say, assess all their various permutations and guess what the prescription will be. But you don't need to be able to do that to say the result is routine and entirely obvious.
I suppose the testing of each eye is independent.
Lady's right. Absolutely. My lady's absolutely right. But I hope you get the flavour of what I'm trying to get across. And that's why this case is about, in my submission, empirical implementation, not empirical research in the wider sense that my learned friend tries to suggest. There's nothing in my submission that would have any effect on the patentability of the discovery of an antibiotic effect in a particular bucket that you dug up on a beach in Cornwall or wherever you'd done it. Nothing at all. And there's another feature about the exercise that's worth drawing attention to. In the case of the eye test, you know that there is in fact an optimum prescription. Just a question of finding it empirically. Likewise, the dose response in our case. You know it's there. Now, can I look at the case law in a bit of detail, not a great amount of detail, but I want my lady and my lords to understand what I say the shape of the law of obviousness is. The first point is to deal with the point that my Lord Sumption put to me yesterday, and that it's not, the question is not whether the words of the claim or the information in the claim are obvious, it's whether it's obvious to make or do something which is in fact within the claim. And of course, we saw that point in the context of novelty and Merrill Dow and Synthon, but the same principle applies to obviousness. And let me make that submission good by going to Medimmune and Novartis, which is Authorities Bundle 4, tab 37, MS 2050. It was a case about identifying antibodies, or more specifically functional fragments of antibodies, by a technique called phase display. And the legal principles of obviousness are described in the judgment of Lord Justice Kitchen, and you can find those in a section beginning on MS 2073, para 84. And you see straight away the structured Pizzoli approach is mentioned and explained at para 85. I invite my lady and my lords to note that his lordship points out it's often convenient but no means essential.
This is para
85.
85, thank you.
It's the very first line, often convenient but by no means essential. bottom of 2073. And if we skip forward to para 92, you see the now classic statement of the flexibility of the question of obviousness, because it has to apply in so many different circumstances, is actually something His Lordship said at first instance, but was approved by Lord Hoffman in Connor, as is apparent from paragraph 92. And the same point is emphasised by para 93 too, by reference to Lord Justice Aldous in Norton. But para 93 is important for more than that, because of the way His Lordship puts the point. I mean Lord Justice Kitchen, just above the quote. The question is, was it obvious to the skilled but unimaginative addressee to make a product or carry out a process falling within the claim? And that is the answer to the question that my Lord Sumption.
Sorry, which paragraph are you in?
93.
93, thank you.
I'm actually looking at the 4 lines above the quote.
Yeah.
And as I was just saying, that is the answer to the point that my Lord Sumption put to me yesterday. And it is a question of fact as to whether or not what you've done, which is obvious, falls within the claim. And it matters not that you can tell in advance that you will be in the claim. And in fact, I go further than that, not that it matters for this case, it matters not that you even know afterwards. The next passage of note in this judgment is 129. It's of course a statement made in the context of the facts of this particular case, but in my submission it gives you a good flavour of the right approach. So this is MS 2081, and you see at 129, the step, in that case, the step from the prior art to the invention was adopting a prior art proposal, carrying out the method that the proposer, Professor Smith, had described. As His Lordship says, it's not a promising subject matter for a patent. He does recognise that this is not completely the end of it if the skilled person would have thought the method would not work. But simply following the proposal using the method identified is unlikely to be patentable. Now, my lady and my lords, my submission is the position cannot logically be any different if the method used is not specifically identified in the patent, but is the common general knowledge and routine way a proposal would be implemented. Can I move on and deal with a couple of additional points as briefly as possible in the time available? And they both arise out of a case called Hallen and Brabantia. They're 2 points that we make at para 118 and 120 of our printed case. So that is MS 224 and 225. And the first, which is the bonus effect, is also referred to in my learned friend's book, Terrell on Patents, which we could turn up in volume 8 of the authorities, tab 91, MS 3597. This is the chapter on obviousness, and I'm actually looking at paragraph 12181, which is on the very last page of the bundle, MS 3597. And you see the well-known quotation from Lord Justice Slade is set out. If it's obvious to do something for another purpose, an added benefit, in this quote described as the golden bonus, is not relevant. In that case, it was one of those corkscrews where it was obvious to put PTFE on the corkscrew, and the bonus was not only did the corkscrew go in the cork, but it was one of those ones where you carry on winding, it comes up. And the passage from Terrell, just above that quote, makes it clear that basically fits with my submission as to the big picture. The statutory purpose is to allow workers in the art to take obvious steps. That's just above the quote. And it's also worth noting that the quote in para 12.182, something I foreshadowed yesterday, I think in response to a question from my Lord Sumption, that the true question is not whether you predict the effect, it's whether the discovery of it is obvious. That's the quote in Bristol Myers Squibb against Norton. That's 12.182. Again, that's all consistent with the explanation I've given to my lady and my lords. What matters is what is obvious to do or make, not whether you can predict in advance all the effects or details incident thereon. My lady and my lords, I'm not intending to turn up Hallam and Brabantio for the second of the two propositions. I'll just refer to what we've set out in the case and tell my lady and my lords that it was approved in the Court of Appeal by Lord Justice Slade in the same case, MS, so it's tab 25, just for your note, MS 1691, lines 40 down to 49. That's the fact that it's technical obviousness, not commercial obviousness, that matters. A further few, hopefully relatively brief points. Even in the case of multiple avenues, it's quite possible that a number, even a large number, are obvious. And I make that good by going back to Brugger. So that's bundle 2, tab 13, MS 1364. In fact, you can see, if you just look at 1363, you can see that this is in a section headed multiple avenues. That's about 2/3 of the way down. And the key thing is the first full paragraph on MS 1364, in particular, the middle sentence beginning secondly at line 12. Now, can I just pause and deal with another one of these shorthand tools that one often sees referred to? It's the could-would dichotomy here. Because often one sees debate about whether, to be obvious, one needs to show the person could or would do a particular thing. And I think one of the submissions that I think it might have been Mr. Mitchison made yesterday got into that. And the first point I make about this is you can't substitute either for the word obvious. And it actually rather depends upon what you mean in either sense. Let me explain why I say that. Could might be being used by someone to say, well, the techniques are available to do a particular thing, so the skilled person could have done it. Now, that's not good enough, because the idea to do it is an important part of the picture, or maybe. So could might not be good enough. But would isn't right also if you take it to mean it's the only thing to do, or even the most likely thing to do. And the reason I'm dealing with it here is because I've just shown you a passage that shows that there may be very many obvious things. And so could and would at either extreme isn't right. And that's related to a further point that we've made in our printed case that I'm not going to go to separately, but it's para 96 at MS 218 to 219, that simply providing alternatives without any additional benefit may be an obvious thing to do. And that's where we cite Hirsch-Celanese in footnote 81. What my lady and my lords will have seen in that paragraph in Mr Justice Laddie's decision in Brugger is a reference to John's Manville, and I am going to address that because I think my lady and my lords will have twigged that that's the case where we have the obvious to try question being raised. And it's one of these tools that sometimes we see. Sometimes it might help, sometimes it won't. And I'm going to address this in a bit more detail because of the prominence it plays in my friend's case, perhaps rather unusually because it's my friend as the patentee that keeps trying to raise the point. And the first point I make about this is that if obvious to try is a question that helps, you've got to be careful about when you ask the question. And in this case, what we're talking about is implementing Dorgan. So in my submission, if one does ask the question obvious to try, in a case such as this, you ask it at that point, when you're postulating whether the skilled addressee seeks to do that, i.e. implement Dorgan. And of course, the findings in this case are emphatic on that. We know that the judge concluded not only was seeking to implement Dorgan obvious, but very obvious. We see that, you've probably seen it already, but MS 399, para 287, just below halfway down the page. So not just obvious, very obvious. And in the next para of the judgment, you see him address the expectation of success, i.e. that tadalafil would turn out to be a viable drug right at the outset. So before one even does even preclinical studies, let alone phase 1 or phase 2. And he says that the skilled person would have a reasonable expectation of success. So that's paragraph 288. So that's a problem for my friend, because if the right way to apply the obvious to try question is then, and in fact when we come on to see his materials on the EPO stuff, we'll see that he in fact says that himself. So it's been asked and answered against him. So that's the short answer in respect of this case. But I'll go on and explain to my lady and my lords how it fits in and what it's normally directed to. And a convenient place to look further in respect of this is Angiotech, which is volume 2 in the authorities, tab 14, MS 1370. And I think as my learned friend yesterday said, this is in fact Connor in the Court of Appeal, but it's okay to look at it because although the House of Lords differed on the result, the explanation of the law was actually approved. And the section on the authority starts at para 39, so that's MS 1386. And his lordship explains that the facts in John's Manville were simple. There was a known process, and the patent was to use a new agent in the old process. In fact, what it was a new flocculating agent in a concrete manufacturing process. And the point is simply that it's good enough for obviousness if the skilled person considered it worth trying. What is clear is that what is being considered is simply the practical efficacy of putting it in that process. And the idea, the whole point of what it's getting at, is that there needn't be a certainty before you actually do it. And the skilled person will consider it likely, in the sense of likely enough technically to be worth using in their concrete making process. And the contrast that is the point that his lordship makes at para 40, mere inclusion in a research project to find out more, or hoping something might turn up is not enough. And that's basically the point in the article by Sir Hugh Laddie that my friend has referred to, but not turned up. The suggestion that somehow something turns out to be obvious because it's worth putting into a research project because that's why people do that to get patents. We say, obvious to try. It's a question that sometimes is useful, sometimes not. But when it is used, it's clearly used in the sense of technically likely enough to achieve the ends to be worth using for that purpose of achieving those ends. And that's a very different thing in my submission to asking whether it's obvious to include as part of a broader research project, or even to try because it might be there might be a commercial incentive of a patent at the end of it. And that's the substance of what we've said in para 107 of our printed case at MS221. And in my submission, the answer is as simple as that. As long as you appreciate we're talking not about the kind of commercial motivation for getting a patent or an academic motivation of finding out more or something that might turn up, the dictum makes perfect sense, and it's merely making clear that it doesn't have to be a certainty to be obvious. Before we put Angiotech away, can I just invite you to note very briefly what's said at para 42 and 43 about Australia. And I'm really just drawing that to my lady and my lord's attention. When we look at the foreign cases, we'll see that Australia is all out there on its own, and Lord Justice Jacob is drawing attention to the fact that that tends to happen, at least at this point in time, in this case. Now, can I move on, if I'm not taking this at too brisk a pace, to address two cases where in my submission my learned friend is simply not taking what's said in context. And they are Technograph and Connor in the House of Lords. Technograph first, it's Authorities Bundle 4, tab 39. So that's MS 2112. And it's a case about step-by-step cross-examination. An after-the-event attempt to argue for obviousness by chopping the route from the prior art to the invention into steps postulated after the event. It's not about a case where in fact it's shown that a skilled person in fact routinely implements a disclosure, following a well-trodden path. It was a case about printed circuits for TVs and radios. And the patentee called expert evidence on obviousness, obviously to the effect that it wasn't obvious, but the defendant didn't call any evidence at all. The whole attack was based upon an ex post facto step-by-step cross-examination dreamt up by counsel. And you see that at MS 2126. Right at the foot of the page, the colourful passage bridging the page, in fact, about counsel making the best bricks possible with sparse straw.
I'm sorry, I think I misheard your page number.
2126.
Thank you.
And the passage that my friend likes is 2 pages further on, at the bottom of 2128. He particularly likes the sentence starting, "It may be taken in isolation," because that's what I think he emboldened or underlined in his case. But what in my submission is clear is that this is about what the case was about, which was that cross-examination being postulated after the event. It's not a case where the judge found as a fact that there are well-known steps or stages that are undertaken. our case is not a case of me as counsel, short of straw, making up these steps, saying, how about phase 1, phase 2A, phase 2B? It's what happens in real life. So this doesn't help, my friend. The second case is Connor in the House of Lords, which is volume 2, tab 15. And that's MS 1392. My friend's reliance on this case is really to support suggestion that one must be able to predict the claim, i.e. 5 milligrams in advance. That's why he likes to go there. That's what he's trying to get out of it. And if you look, whilst you have that open, also at para 78 of his case, so this is MS 154, you see a fragment of a sentence is plucked out right at the bottom of MS 154. And we'll see the quote in context. It's perhaps unfortunate that it's been cut short at that point, because all you need is the next few words to see that it doesn't help my friend at all. So actually in the case, so that's tab 15, MS 1392, the principal opinion is Lord Hoffman's. Everybody else, including my lady, agreed. And the point of principle here was how to identify the inventive concept. And you see that in paragraph 3, in particular the end of that paragraph at the top of MS 1398. And the invention concerns stents inserted into arteries to prevent artery walls from collapsing. And what happened is that you had this thing called restenosis, which is an exaggerated healing process where you sometimes see it on trees, actually, where you've got a grafted tree and you get a big bulge. It's that kind of thing. And they themselves would block an artery, and that's explained, I think it's paragraph 5. But the claim in issue was claim 12, and you see that by looking at para 11 on 1399. It was a stent coated with Taxol, I believe a molecule obtained from a yew tree, hence the name derived from the word taxus, and the stent was for treating or preventing recurrent stenosis. And what happened in this case was that the extent of the disclosure in the patent, or rather the alleged lack of it, had been used in the courts below. And you see the narrative of how that happened in paras 15 to 18. I'm not going to ask you to read it all now, but that explains Mr. Thorley's manoeuvrings to seek to avoid the true question. And the guts of it was to suggest that the teaching of the document, i.e. the patent, was no more than the idea that Taxol was worth trying, i.e. not that it would treat restenosis. And you see at paragraph 16, that submission identified, and paragraph 17, Lord Hoffman explains that it's an illegitimate amalgam of the requirements of inventiveness and either sufficiency or support or both. And the correct question is identified at the end of para 17, the foot of MS 1400, whether it was obvious to use a Taxol-coated stent for the purpose of preventing or treating restenosis. You see Mr. Thorley had sought to avoid that question. And it's in that context that we see para 19, which is the paragraph that my friend relies upon, at the top of page MS 1401. And the point is one assesses obviousness by reference to the claim, not some vague paraphrase based upon the extent of the disclosure. It's the contrast, the last few words of that sentence that are important for you to understand what the case was about. It's not suggesting you've got to be able to predict the words of the claim. And there's nothing in my submissions that's inconsistent with that. I am assessing obviousness on that basis. My friend tries to say I'm trying to say the claim was to some form of dose response. I'm not. I'm referring to the dose response to explain why the skilled person already has in his repertoire the 5 milligram dosing. Finding the dose response is what he does. When he does so, he finds efficacy at 5 milligrams. I don't need to take you through the actual reason that the House of Lords differed from the Court of Appeal. I'll just give you some references. It was basically a difference of view as to the teaching of the patent. There was much more significance attached to the weight of something called a CAM assay. My lady and my lords don't need to be worried too much about it, but you'll see it, for instance, in para 27, and again in 38 to 39, which is directly referring to preferring the Dutch court's decision, and indeed Lord Walker in another helpful short concurring judgment, para 51. So the upshot is this case doesn't advance my friend's argument at all. It's entirely consistent with the way I'm approaching it and the way in which the Court of Appeal did. And it's certainly no support for the idea that the skilled person has to predict the doses. Now, there's one more area on domestic law, and that's the Gideon-Richter point. This, I thought, was the whole point that was said to be a point of public importance to bring this case here. The point of principle in the written submissions, the central point appeared to be that Gideon-Richter was wrong by taking account of information ascertained on the way, experiments that have been done, tests, whatever they may be. I was rather surprised that my learned friend Mr. Mitchison never mentioned it at all. I do still need to deal with it because some of the submissions Mr. Waugh made did appear to still be maintaining the point. And the point is, can you take account of information not actually known at the priority date? And just for your note, they say that's the fundamental error in para 34 of their printed case. And it's the same complaint when they refer to Gideon-Richter as the law going wrong at that point at para 150 and 151. The first point I make about this is, in fact, Lily's argument that's radical. It's not without note that you've got three very experienced patent judges in the Court of Appeal in this case, about as strong a patent court as it's possible to imagine, none of them expressing themselves as breaking new ground. And you will recall that we gave my lady and my lords an extract from Mr. Justice Henry Carr referring to this case, that's in our printed case at para 13, to the effect that this was just applying settled principles. And when we see the Dutch case, we'll see that in substance that's what they're doing when they refer to the walking down the one-way street. That is talking about empirical implementation. And we also point out that the argument is not only against all of that, but actually Mr. Justice Burse himself took the approach where you could take account of information. That's the whole point of his investigating and finding what the skilled person would do. So that's all of the section of para 288 onwards. And I think my lady and my lords get the best explanation of why you can do that in the paragraph that we've given you from KCI at para 102 of our case. So that's MS 220. This is Mr. Justice Arnold explaining that information that the skilled person would seek out, whether you look it up or do tests, is legitimate to take into account. It's not because it's common general knowledge, it obviously is not. It's because the skilled person would seek it as a matter of course. That is bang on what we say the routine empirical implementation type scenario. And so I hope that my lady and my lords are beginning to see why Mr. Justice Henry Carr described this as a settled approach. And in fact, the example Mr. Justice Arnold gives in this paragraph is noteworthy. He points to the pharmaceutical formulation as an exemplar. All patent practitioners know that the guts of those cases, one takes an active drug, tests some properties of it, and also routinely tests things like compatibility with excipients. And of course, what you do as an ordinary skilled man is dependent upon that information. And my lady and my lords need not look very far for such a case. It is the other patent in suit in this case. 092 was a formulation patent. Our case was the same. It was obvious over Dorgan. Claims of 092 were to a dosage form, typically a tablet, where the particles of the drug in the tablet have been micronized, i.e. ground up into unusually small bits. Such a thing is not obvious per se, but it's the first thing you do to deal with a drug once you find out, which is routine, that it's poorly soluble. It's basically the same idea as using granulated sugar instead of a sugar lump. The same mass dissolves more quickly because of increased surface area. But my point to my lady and my lords is it is a response to ascertaining the solubility information, which is a routine way of going about formulation. And so it's not contrary to principle, statute, nor policy, because the question is, what is it obvious to do in light of the state of the art? And I'm not feeding information in illegitimately, because that is part of what you do. The question is still being asked in the light of the knowledge that the skilled person has at the relevant date. It's just that it's taking account of empirical implementation. It's part of the symmetry that I pointed out when showing my lady and my lords the big picture. And you need to do that to properly assess the critical technical contribution, i.e. the difference in the class of products and processes in the skilled person's repertoire before the patent and after the patent. While I'm on policy, can I just deal with another theme that's in my friend's submissions, and that's that pharmaceutical research is all very difficult, costly, and needs protection. My lady and my lords have the point that where I've been through and said you can't just wave your arms around and point to different work, but in any event, you should be very cautious about those kinds of sentiments in a submission which is to apply to all patent law in any technology. Empirical implementation would be excluded from the obviousness side of the coin, whilst remaining alive on the sufficiency side. And the reason that you needn't be worried about the points that my learned friend makes about pharmaceutical research is because there are very specific forms of protection which do provide protection. They are sympathetic to the fact that there is routine but uninventive work that industry often has to undertake. And we've set this all out in our section in para 44 onwards, which is MS 202 through to 205. And just to pick out the key things for you. First of all, as you know, Swiss form claims have achieving the technical effect of efficacy as a functional feature, but as a concession, patentees are allowed to apply early and secure patent protection if they make a plausible disclosure. And certainly three of my lords will have heard enough about that in the last case. That's what that was all about. So you can apply early and secure your patent, but then you will have to do your clinical trials for regulatory purposes. So what we have is a system called the SPC system, and that allows you to be compensated for a delay in marketing an invention that's often caused by that need. So that protects that work because you've got a monopoly you apply for early, but you can't commercialise till later. And the work that goes into the clinical trials is itself protected by the rules on data exclusivity, which we've explained in para 52 at MS 204. And so this is an industry where empirical implementation is costly, but it's not inventive, and one gets exclusivity not through patent protection, but through the ability to prevent others relying on the fruits of that work to secure their own marketing authorization. So there's nothing in my friend's attempt more generally to complain about expense at all. Now, the very last domestic case I want to show you is Actavis and Merck. It's an important case, and I confess I was in two minds as to whether to start with it or end with it. And I'm doing it in this order because I believe that once you see the bigger picture that I've shown you, you understand exactly why Lord Justice Jacob said what he did. So it's Authorities Bundle 1, tab 4, MS 1011. It was a drug called finasteride. The disease was a form of alopecia, which is shortened to AA in this judgment. The use had in fact been suggested previously, but as we shall see, the special facts of the case meant that an advance in the common general knowledge meant that by the priority date it would have been understood not likely to work. And you see that just in para 3 of the holdings at MS 1013. We don't need to get immersed in the detail, but it was to do with the fact that the hormone that it would inhibit was by the priority date known to be existing in two types, type 1 and 2, and the drug only inhibited type 2, of which none is detectable in the scalp. To get around that validity problem, the patentee included in the Swiss form claim the dosing regimen. And the main issue was whether that was good enough for novelty, because there had been a case in the national courts that suggested that the dosing regimen wasn't good enough, and there'd been an opposite case in the EPO indicating that it could be. And the key part of the decision is paras 29 to 32, so that's MS 1021. Para 29 is the paragraph my friend showed you, and it makes the point that there's no reason why a novel, non-obvious dosage regime should not result in a patent. And my friend seeks to make much of this, but we have no quarrel with this at all. The key word is if. If a novel, non-obvious regime is invented. The key paragraph in our submission is in fact para 32, where you see Lord Justice Jacob is recognising that nearly all dosage regimes will be obvious. And what's important is the reason he gives. It's standard practice to investigate appropriate dosage regimes. He goes on to explain it, explain that it will be an unusual case, which that one was, but ours isn't, for the dosage regime to confer validity on an otherwise invalid claim. They're flat against my learned friend's point of principle that you can't take account of what you find, but also gives you a very good flavour of the likelihood or the regularity that dosing regimes are likely to be inventive. It's also worth noting Lord Justice Jacob's reference in para 42 to a German Supreme Court case, also concluding that a dosing regime could confer novelty. It's the Carvedilol 2 case. So MS 1024. But it's noteworthy, particularly because at the foot of the page, in fact the passage bridging the page, the court went on, although it could confer novelty, that one was obvious, because it would have been arrived at by routine investigation. Lord Justice Jacob says that's a typical example of what he'd been referring to earlier. So it's been recognised both in para 32 itself and the later reference to Germany, that if it's a dosing regime that you arrive at by routine investigation, obvious. Just while we're on this, can I just show you, it's of interest to look at the way the BMS case was referred to, MS 1027, para 53 and 54. What you've got is something in the prior art called Winograd in that other case, and somebody tried to claim basically the same thing by adding another piece of information about it. It's number 5. And you can see that that's not good enough. So I only draw attention to it just because it's another example of more information about something that's old is not contributing. The EPO is the next topic. Can I tell you what my submission is as to the overall picture? My lady and my lords know that there's a preference there to use the framework of the problem-solution approach. One of the things you sometimes hear is that the problem-solution approach necessarily involves hindsight because you're seeking to identify the problem that the pattern has solved, so you need to know about it. And so you have to be a little bit careful in framing the questions. And actually, you have to be particularly careful where it's an unexpected bonus effect or an unknown piece of additional information. Because if you frame your questions like that, you get the wrong answer. Doesn't mean that in very many cases that kind of approach is useful and helpful, but you just have to be quite careful about how you frame questions where you're into this kind of case where there's a dispute over whether really you're just providing more information of something that you do anyway. Can I tell you what I say you can see in the system? First of all, as I've shown you under domestic law, the question is whether it's obvious to do or make something within the claim. It's not as if the problem-solution approach or the question in the EPO allows you to try and say you've got to predict the claim. That's my first submission. The second is a stepwise approach is perfectly permissible if that's what the skilled person would do. And thirdly, it is perfectly permissible to take account of information ascertained routinely if that's what the skilled person would do too. In other words, my friend's point of principle is wrong. Now let me make those submissions good. Can I first of all go to Authorities Bundle 8, tab 88. This is the, so it's MS 3563. These are the EPO guidelines. And if you look at para 4, the bottom half of the page, about 4 lines in, you see that the claim is not allowable if it would be obvious to arrive at something falling within the claim. So it's MS 3563, just below halfway, about 4 lines underneath the heading obviousness. And I've explained that one aspect of this is that the bonus effect doesn't count, doesn't turn something otherwise obvious into something inventive. And it's the same in the EPO. Let me show you an authority on that. Bundle 6, tab 62. MS 2825. Case starts on 2815. It's all in the language of the problem-solution approach. But what I need is one paragraph, in this case, at the bottom of 2825, and over to the top of the next page. The thrust of what's being explained here is that one doesn't get inventiveness by another additional effect. So you see 5 lines up from the bottom of MS 2825, identifies the problem-solution approach, then says, reading over the page, once a realistic technical problem is defined, once it's established a particular solution to the problem would have been envisaged by the person skilled in the art, the solution lacks inventive step, and that's not altered by the fact that the claim inherently also solves further problems. So what that is saying is that another problem, i.e. another effect, can't change, whether it's obvious, if there's already a realistic problem solved. And in our case, it's finding the dose response. In fact, you could even frame it as just implementing Dorgan. This is perhaps an opportune point to address the Wellcome case relied upon by my learned friend. And as I've understood the argument he makes, he suggests that he can have a patent, at least in a dosing case, if it brings an unexpected benefit. And that's a somewhat surprising proposition because it's contrary to the policy underlying the scheme, contrary to the case I've just shown you, and in fact contrary to not just UK national law, but we'll see that that's the basis of the German court's decision in this case. My friend said he gets it from Wellcome, which is tab 64 in Authorities Bundle 6. This is an unreported decision from May 2001 and was a case about antiviral nucleosides.
Sorry, did you give us a page for this?
2842.
Thank you.
And it's a case about antiviral nucleosides. So it's not a straightforward pharmaceutical case. It's about nucleosides are nucleotides, which are the building blocks of DNA, but without a phosphate. And it's about a substance that interferes with virus replication in cells. And the details of the discussion is about concentrations, not in terms of milligrams, but moles of the substance. It would appear both in blood plasma and in tests on cells, and I'll show you why we say that in a minute. And it's not at all clear from this as to how that transposes into the dosing of the claim, or, perhaps most importantly, that there's an equivalent standard route in the sense of the phase 1, phase 2A, phase 2B that we have in our case. And a big problem in this case was that the point on dosing was only raised at the hearing. And let me show you that. If you go to MS 2845, you see the left-hand page of this. The claims that have been granted are at the bottom of 2845. There were 3 auxiliary requests filed before the hearing, so that's 3 sets of fallback positions. And you see that MS 2846, about 2/3 of the way down, for the first of them, no dosing. Second and third are at the foot of page 2846 and the top of 2847, no dosing. And it's just the 4th auxiliary request filed at the oral proceedings that you see on 2847 where it's introduced. And that you see in claim 1 that there's a dosing limitation put in for the first time at the hearing. And it really is very difficult to work out what's going on from the judgment as to what materials there were explaining what the skilled person does, if anything, as a matter of routine, over the publication that was relied upon, whether we've got the same type of phase 1, phase 2, and so forth. And what you do have is that you have, at the top of MS 2870, the document itself identified a concentration in terms of 250 micromoles used in tests on a retrovirus in mouse cells. So that, we think, is a concentration on a cell culture. The paragraph at the bottom picks out that the patent had specified that it had identified that doses administered should achieve peak plasma concentrations, so that's in blood plasma as we understand it, of 1 to 75 micromoles. We infer, it doesn't say, that the suggestion is that the doses of 5 to 1500 milligrams achieve that. We can't tell from the judgment and this brief reasoning whether there is, as we say, any kind of routine route of seeking a dose response. So it really is very obscure to try and work out what the underlying facts were and what the reasoning might be as to, well, certainly it's extraordinary in my submission to suggest, if it appears to be my friend's submission, that this is authority for the proposition that the most obvious way to implement Dorgan is patentable because one cannot predict in advance where that route gives you what dose, and or because you have a bonus effect. This is a very different case on different facts, which was the point was introduced right at the last minute, and one doesn't know when reading this whether in the context of nucleosides, which is not just an ordinary pharmaceutical, you have the same established well-trodden path. So my second submission, that was an aside dealing with that on the first submission. My second submission is that stepwise analysis is permissible if that's what the skilled person would do. And we're back on Authorities Bundle 8, tab 88, top of the EPO guidelines 3567. You see the first paragraph on that page, bang on point in my submission, and all of a piece with my overarching submission. One looks to see what the skilled person actually does, what they're already able to do in the sense of what's in their repertoire. And we've given an extra case in our printed case, but I'm not going to take time to ask my lady and my lords to turn it up now. The third and final submission that I say you get out of the EPO materials is the permissibility of taking into account information ascertained routinely. And we've given my lady and my lords a case that's actually in the bundles at Bundle 6, tab 57, but we've explained it in some detail in our written case, so I'm going to just show you that, if I may, to save time. It's para 128 to 131 on MS 228. It's a case about hepatitis B, and in fact the patent arises from the same work as was subject to the Biogen patent in Biogen and Mediva, although it was a different patent. And basically, what this case held is that where the prior publication motivated a skilled person to continue the work to find out the sequences which were not known at the time and obviously couldn't conceivably be predicted, to actually continue with what had been disclosed and finish the work. And you see, for instance, the very last quote that we set out, the penultimate quote in 131, the bit underlined, is all in terms of filling in the gaps in knowledge. And you're allowed to do that because that is in fact what the skilled person would do, having read the prior art in that case. Now, there's one other point that I make actually in relation to my learned friend's case. Para 117, so this is MS 165. This is the point about timing. You recall earlier on I said if it's helpful to ask obvious to try. You look at the beginning when you seek to implement Dorgan. And that's exactly what's reflected in paragraph 117 in my learned friend's case 165. What he's basically trying to say is to exclude, well, he's put it there because he wants to exclude later acquired knowledge, but what that actually shows is that the question of prospect of success is asked at the beginning to decide whether this is something that the skilled person would be doing. Now, the whole point of the EPO section in my friend's skeleton is so that he can say and simply assert that the problems and the questions would be framed in the way that he suggests. We see that in para 121 of his case, and he simply says this is how the problems would be framed, and he frames it by reference to the bonus effect or the unpredictable nature of 5 milligrams, and he says that it would be to an improved dosing regime. If one adopted the problem-solution approach, that would be highly contentious. The problem could equally easily be cast as ascertaining the appropriate dosing, or identifying the dose response, finding the region the skilled person routinely seeks, or even simply implementing Dorgan. And it's certainly not right to say that the problem is an improved dosing regime. Dorgan doesn't have a dosing regime. And the point that I'm making to my lady and my lords is that if you decide to do this, the case often wholly turns on how you frame the questions. And so you have a big fight about it. And in some cases, it's better to just get on and answer the question of obviousness. And you'll see, when we look very shortly at the foreign litigation, that's what the Dutch court did. So it's not right to say that everyone on the continent always does this problem solution. In that case, on this patent, they decided not to. They just got on and answered the question. The Portuguese court did follow the problem solution approach, and there was a big ding-dong about how you framed the questions, and it was resolved against my friend, and so they revoked the patent as well. But this is the kind of case that illustrates that sometimes it's helpful, but in other cases it may be better to just go straight to the question of obviousness. In either case, though, if you're going to do it, the case is won or lost in framing the questions. And we don't accept for a minute what my learned friend suggests, that, if you do what the EPO do by problem solution, this is how you frame the questions. That brings me to the foreign litigation, which I'm going to deal with very briefly, if I may, just to bring you up to speed as to what the current state of play is. The thing that you'll be most interested to see is how other EPC courts have dealt with the issue, because they're applying the same law to the same patent. And normally, the courts that are of most interest are the ones that have the most experience and the most respected in the EPC system, are the Dutch and the Germans. With all due modesty, we're in there as well. There are three of us. And certainly, if I turn up at a trial in front of a patents judge, they ask, what have the Germans done or what have the Dutch done? With the greatest respect to my friend and to the patent offices in the Czech Republic and Poland, I've never been asked what has happened there. So one's normally concerned with the courts, and there are two that are particularly important. And in both the German and the Dutch courts, we have the same result. Both of them adopting an approach which is inconsistent with my learned friend's point of principle, because they're taking account of information that's ascertained on the route. Of course, it can be said against me, same patent, same law, but the evidence in each court is never exactly the same. That's true. But as a matter of principle, the way they've gone about it is entirely consistent with what I have submitted as to the appropriate course or the appropriate way to do it. And in particular, as I've said to my lady and my lords, that what happened in Germany is a rejection of a bonus effect argument. Let me just show you that. If we go to MS 310, it's bundle 7, tab 71.
Sorry, MS.
3111.
Okay. 3111.
3130 is, I think, where I want to go forward to. In fact, it's further than that, because 3134, I do apologise. And right at the bottom, you'll see consideration of Mr. Justice Burst's judgment. Now, one of the things that my learned friend tried to say about the Dutch judgment is that they had both Mr. Justice Burst and the Court of Appeal. The Germans didn't. They just had Mr. Justice Burst. And you see at the bottom, they understood the effect of the findings was to be that the dose finding study included 5 milligrams. That meant that it was itself obvious. You see they draw attention to Mr. Justice Burst relying on the surprisingly advantageous side effect profile. And they are quite clear. Under German law, that's a bonus effect, not allowed. So far as the EPC courts are concerned, those are the two most important ones. I could spend time taking you through the Dutch one because, frankly, from my point of view, it's great, but I'll just invite you to read it because I don't have enough time now. But there are others in the EPC countries which are still important. We've got Portugal, Belgium, and France. In every case, the patent has been revoked. France, they didn't get as far as obviousness, so I can't put too much on that. It was revoked earlier, they look at basically issues in a particular order. The other ones, obviousness was a ground for revocation. And as I've said to you, Portugal particularly applied the problem-solution approach. There was a fight about the problem, and they resolved that in favour of the person attacking the patent. Holland didn't even bother to do that. They just said the same result would probably follow. So that's all the cases on the merits on the EPC cases, all one way. My learned friend relies upon Denmark. Denmark is simply an interim injunction application. It's about 1.5 pages long, and all they decided was a probability. So in terms of the courts in the EPC countries, all one way, There are 3 other countries where equivalent patents have been litigated: Japan, Canada, and Australia. The first 2 of those were findings that the patent was invalid. My learned friend is right in pointing out that there's a procedure in Canada which is in effect an approval for regulatory certificate, which doesn't actually result in it being revoked, but it's still a decision on the merits. So he's right to pull me up on that. We repeated something that was in the French decision about it being cancelled, and I accept that correction. Australia is the only one that's different. And you see, I've seen what my Lord Justice Jacob said about Australia. They do apply a very pro-patentee approach. And actually, it's worth noting that Australia, the claim is up to 20. You would think, oh, bigger claim, easier to hit. But what that shows you is that there is the facts and the approach there must be very different, because that would cover even the on-demand doses, the 10 and 20, all in the Australian claim, upheld.
Australia, I think I'm right in saying, has also explicitly rejected the notion that EPO cases transfer much right on Australian.
I think that's right. Australia definitely, well, yeah, exactly. I don't. Well, I've shown you what Lord Justice Jacob said about Australia in the context of an obviousness case. So you've just got to be very cautious about Australia in my submission. Now, I'm going to deal with my respondents' notice points as quickly as I can, because I've got about 6 or 7 minutes.
That's about it, 6.
Yeah. So the reason I say that they arise and actually should be of concern to my lords or my lady is three points. Firstly, if this case raises any point of public importance, it's the broader one, namely whether there's a symmetry in the law so far as enabling disclosure is concerned. And that's a point that impacts across all of the objections, including priority. Second point is the test applied by the Court of Appeal as to whether something has been plausibly disclosed was that it had applied in Warner-Lambert, which we now know from the majority decision of this court last week is too low. So they were applying the wrong test. And thirdly, the way in which my friend seeks to put his case on inventive step, the matters that I took you through earlier, is totally inconsistent, in particular with the priority document. Now, let me show you very quickly how this was dealt with below. And I'm going to deal with mainly priority and explain to you why it's a good added matter objection as well, right at the end. If we go to the decision of Lord Justice Kitchen, I'm in MS 305, 83. Paragraph 83. And you see that His Lordship rejects my submissions and expressly refers to basically the standard of plausibility, which is Warner-Lambert in the Court of Appeal. So that's the first thing he does. And then he says there's ample material in the priority document to satisfy the criteria. Firstly, tadalafil is specifically identified and said to be especially preferred. Then there's the table showing that it selectively inhibits PDE5. That is no more than you get from Dorgan. That's just that tadalafil will work. We're talking about a claim at dosing at 1 to 5. So you've got to have basis or a reason to believe it will work at that dose in my submission. So thus far, we've not got anywhere to give any kind of reason as to why it will work. Example 4, that is tadalafil. That is a test which is simply a test on safety. It is a test basically directed to the nitrite problem with sildenafil, and they tested people that didn't have erectile dysfunction to see what their heart was like. What's more, it's 10 milligrams, it's not in the dose, so that doesn't get you anywhere near thinking that 1 to 5 will work. Example 5 is not tadalafil. It is actually an example of 2 separate tests. It's 5 up to about 100 when you look at them, the doses, and it shows that this particular one is one that works at 5. But the key thing to actually understand about the priority document is that it is a massive document disclosing what you can do to select what they call as a selective PDE5 inhibitor, which is a massive class of things. And let me just show you that document, because if you go to MS 504, that's the priority. Sorry, 466. This is the priority document. The first thing that it does is refer to sildenafil, page 2, so that's MS 467. It then tells you that if you select products with particular properties, and they are the 3 properties that you see on page MS 468, it's going to be better than sildenafil, and it's all about working up to 20. The detailed description explains, in a passage that my learned friend likes, that you'll put it in a box with a package insert that tells you what the dosing is. The dosing is up to 20. This is the passage that he drew attention to between on MS 471 and 472. The dosing is up to 20 as a general disclosure, preferably 5 to 20, more preferably 5 to 15, most preferably 10. That's right at the top of MS 472. That is telling you that most of them will be working in the more preferable range. And of course, what my lady and my lords will have seen, that what is happening is that they're now trying to claim the little bit that got thrown away straight away from the up to 20. Not preferred at all. The other thing that is missing from the statement of facts and issues that you should know is that there's a massive bit in the document about how one goes about selecting PDE5 inhibitors. If you look at the bottom of MS 474, you see that they are said to vary significantly, and there are pages and pages of different places you can go to find them and formulae that you can use. And it's true, one of them is tadalafil. But the idea that this discloses that the dosing window of 1 to 5 is where tadalafil will be efficacious because there is a test on 10 showing it's safe is, in my submission, hopeless. If you apply the right test, that there has to be a reason to believe that it will work. What is that reason? I suspect my friend's going to have to say, you think that every single PDE5 inhibitor plausibly is disclosed as working at every single dose in 1 to 20. That's not what that document says, but there's no other way of arguing it. So that's basically the argument on plausibility, on priority. If the invention is what he says it is, showing that 1 to 5 is better than 10 and 20 for tadalafil, that's absolutely nowhere there. And the reason there's added matter is because they've identified a new dosing window. The substance is what matters for added added matter. They've identified a new dosing window, which is 1 to 5, which is where they say the benefit occurs for tadalafil. And again, not in the application. So that's a whistle-stop tour. I've probably done an injustice to the point that's explained in more detail in our written case. So I would invite you to look at that when considering those points. They only arise if you're against me on obviousness. Do you have any questions on obviousness or even the other?
No, thank you very much indeed, Mr. Speck. Thank you. No. I take it your learned junior does not wish to follow.
My lady, my lords, no.
May it please the court. My lady, in reply, I propose to take the same track as my learned friend. It's generally more convenient. There are a significant number of points to correct, and I will do so as quickly as I can, but it will mean I won't actually have time to go to many of the documents, but I will give the references. And if I don't give them clearly enough, please stop me. Yesterday, my learned friend started with his series of 7 propositions, essentially his statement of principles to see what he called the big picture. They were and are the bedrock of his submissions. The court will not see those principles so stated in any previous judgment or text. And the reason for that is that they weren't advanced below. I don't even recall the word repertoire being used. Indeed, they're not even presented as such in his written case. And if the word repertoire appears in his written case, I'll be corrected. If all those propositions were accepted, the law of obviousness will be turned on its head and many valuable patents rendered unpatentable at a stroke. Time does not allow us to unpack each of the propositions individually, but it is right and proper to sound a huge note of caution, if not alarm, at the way in which we've got to this position, and it's worth reflecting on the following. The judge at first instance prepared a careful and balanced judgment in which he applied a conventional approach based, as he said, it was on Lundbeck approved in Connor. The Court of Appeal, then, we submit, overturned that without a clear statement of where the judge had erred in principle. And my learned friend, Mr. Speck, didn't actually correct that in my respectful submission. To support the Court of Appeal's judgment, my learned friend then comes up for the first time in oral submissions with a series of 7 propositions, which are not even so stated in his written case, and unpacking them from yesterday's transcript was indeed hard enough. Significantly, those propositions were not based on any pre-existing case law on obviousness, such as to be found in Medimune, or Connor, or Lundbeck, or any of the decisions that we have at higher authority. Instead, quite remarkably, he based his submissions and propositions with cases based on novelty such as Merrill Dow, such as Synthon, and insufficiency such as Bargen. Indeed, he said Synthon was the most important of all. My learned friend's propositions are at their core flawed and would have dramatic, unforeseen, and unintended consequences on the law of obviousness. In our respectful submission, this is not how this court should be asked to make binding precedential law at the highest level in an area of such commercial significance and of significance to research and development as a whole. I'd go further and submit that this is actually a terrible way to be inviting this court to make new law. We set out in our case at section L what we submit is a correct approach based on orthodox law. That's to be found at MS page 184. If there was a time in which to come up with propositions contrary to what we submit is the correct approach, a time to do so would have been in his case in reply. My learned friend may say, well, it was somewhere stated in our case, but these propositions were not. And to see them supported by cases on novelty and insufficiency, on the basis, although he didn't use the word, that there's some golden thread that runs through them all, is so dangerous. We have explained already how what my learned friend is proposing diverges from EPO case law of the highest authority. the enlarged Board of Appeal in G2008. The dosing regime case, and I'm going to leave my learned friend Mr. Mitchison to follow, time allowing, on the cases, but there is a deafening silence on G2008. Deafening silence. The most proximate, the most important EPO case of the highest authority there, and my learned friend just has not grappled with it at all. Furthermore, it's not just that. There is a whole area of patents which are known as improvement patents and selection patents, where within one prior patent disclosure, improvements are regularly made and patented, and the system operates to encourage such improvements to be made. The olanzapine case is a good example. And the proximity is actually quite close, because my learned friend sought to make something of the Dogan patent, where he accepted it's got no guidance on dosing. One is entitled to take Dogan, whether it be ICOS or Lilly or Glaxo or anybody, and to make an improvement. It's all within the skilled person's so-called repertoire to do so. But that doesn't cast aside all those patents, and the court has not been... Has to be not obvious, my lord. That is the statutory question. No, with great respect, my lord, it is not a question of whether the kind of testing is obvious or not, because that is the process. It is saying, basically, if the process is obvious of getting there, and this comes back to the answer I gave my lord yesterday, it just throws out of the window the actual wording of the claim and the technical effect associated with that claim. It's the very trap that the eloquence of my learned friend Mr. Speck invites my lord to fall into, and he did so with the court below. And it's not the law as G2008 specifies. And even without consideration of improvement patents and selection patents, of which this court has heard nothing, time simply doesn't allow us to go down all these byways, significant though they are, my learned friend's new approach would render those patents invalid at a stroke on the basis of a series of flawed, unprecedented propositions which he seeks to set out for the first time in his oral submissions to this court. And that's why I submit this is not the way for new law to be made. I appreciate this court may well be faced with inter aurem arguments on a regular basis. However, as a practitioner with 36 years of experience, both here in the EPO, it's my duty and obligation to draw this fact to the attention of the court. I don't want to be told later, why didn't you tell them about the significance of what was being argued? Turning then to my learned friend's propositions as such, the 7, we have no quarrel with the first. As to his second, he refers to a symmetry or balance in the system, and we agree that it is a delicate balance and one which the judge at first instance well explained. And I invited the court to go and read Mr. Justice Burse's balanced judgment on policy and symmetry. And to interfere with that balance in the way that my learned friend would have the court do has serious ramifications. His third proposition is the most critically flawed. He says that, and I quote, the monopoly cannot cover that which the skilled person was already able to do or make having regard to the state of the art. And he went on to say that what he was going to use as a shorthand for that was that which the skilled person could already do, that which is within the skilled person's repertoire. So let us be under no misapprehension. My learned friend's approach is a could test. What can the skilled person do? And he applies that approach across the board to novelty and obviousness, the approach test being what the skilled person could do in the light of the state of the art. He said to the court this morning that his case didn't interfere with the patenting the discovery of a valuable new antibiotic dug up and put in a bucket on a beach in Cornwall. Well, that's not right. It plainly does if one takes his propositions, because it's within the skilled person's repertoire to dig up samples and screen them. The secret, actually, is with expectation of success. It's with a surprising new technical effect associated with a very new effective antibiotic. Just being in the repertoire, just being something the skilled person could do is not the test. And this is what is so radical about my learned friend's approach. It has long been established that could alone is not enough for novelty or obviousness. It is the fact that all successful research can be done from what is known. We know that because it has been done and found to work. And it can always be said, therefore, that it can or could be done, and thus is in their repertoire. That's the fact with these cases. Cases like olanzapine, where within a very broad disclosure, a new antipsychotic drug was dug out, rather like the soil sample on the beach. The previous patent covered many, many compounds. And indeed, just to reflect there for a moment, the argument in that case advanced was all the skilled person had to do was to conduct a structure-activity relationship. He had to ring the changes on the molecule within the broad previous disclosure. That was all within the medicinal chemist's repertoire. Straightforward. But because you had actually highlighted on a compound that was within the genus, and if it be a new product within the genus, if it be a new dose within the genus, and it has a surprising technical effect, it can and should be patentable. Time doesn't allow the court to go to it, but can I just ask the court to go back, when time allows, to Connor, Lord Justice Jacob, which was expressly approved by Lord Hoffman. The reference is Authorities Volume 2, Tab 14, MS 1386 at paragraphs 40 to 41, and ask them to read that again, and also to note the sentence in the middle of the quote from Saint-Gobain in paragraph 40. And in the example that Sir Hugh Laddie gave in his article, again to give the reference at Volume 8, Tab 89, page 3578, finding the new vaccine, all involves steps that are within the skilled person's repertoire. All straightforward empirical work. But it was for that very reason that Lord Hoffman and Lord Walker were both highly influenced by the fact that if you stripped expectation away, expectation of success, you would basically be failing to reward what is vital and essential research and development that we all need to stop deaths from flu next year. The fact that the skilled person could do that research is manifestly not enough. And we submit, my learned friend comes right up against decades of established EPO jurisprudence that could is not enough. The could test has long been rejected for the same reason as clearly set out in the passage which my learned friend Mr. Mitchison referred to. And just to give the reference again, this was in the EPO case law book at Volume 8, Tab 87, 3556. That is to say, in terms that the question is, and I quote, not whether the skilled person could have carried out the invention, but whether they would have done so in the hope of solving the technical problem or an expectation of some improvement or advantage. That is the law. And we ask the court to reread that section as Section 5 and note the last sentence at MS 3556. For those reasons, his third proposition is wholly flawed. His fourth proposition was that there's no contribution when all the skilled person has done is to discover more information about products or processes already within the skilled person's repertoire. I ask the court to bear in mind that his repertoire was shorthand for what the skilled person could do. So at the outset, his submission builds on an illegitimate premise, as I've just explained. Second, if it weren't based on an illegitimate premise, it's clear and well established that a new technical effect is more than just more information about products or processes which the skilled person can carry out. On the facts of this case, the technical effect is not just more detail, as he put it. It is a different technical result which, on the judge's findings, are unexpected. And it's for that reason, for the reasons explained by Mr. Mitchison, and which Mr. Speck did not answer with reference to G2 of 08, consideration of the technical effect is an intrinsic part of the obviousness analysis. And for that same reason, the technical effect is not just an unexpected bonus, as he submitted. And my learned friend Mr. Mitchison will come back to the bonus cases that my learned friend Mr. Speck did refer to. But in any event, Merrill Dow makes it clear that inventions are information in any event. To give the reference, at MS 2104, line 32, in volume 4 of tab 38. He says in his fifth proposition, and this was to say that our approach was that it was not permissible to take account of information not known at the priority date, is extreme and contrary to patent law. We submit that having regard to the state of the art as of the priority date is a position mandated by the statute, and even if it were justified to take into account some post-priority document date information, it's not right to do so in a way which contravenes technograph with a series of individually obvious steps which cumulatively lead to the invention. This sort of stepwise analysis has the effect of treating the results of each step as if it were new prior art and a springboard for the next allegedly obvious step. And we submit that plainly contravenes the statute that mandates that the prior art is limited to the state of the art at the priority date. And again, my own friend Mr. Mitchison will refer to technograph in following. My own friend's sixth proposition was to say that if his fifth proposition was a good one, it would apply whether or not there's an unexpected benefit or not. And again, we submit, for the reasons explained with reference to the EPO case law, the problem-solution approach, that is not the law. A technical effect which is unexpected is the very contribution that allows a finding of non-obviousness. In this case, a dose which was merely an alternate dose without a technical effect would be obvious as the judge found, so 25 grams. Inherent in the proposition 7, and certainly this one was very difficult to unpack from the transcript, my own friend submitted, it's page 87 if we have the benefit of the transcript, my own friend submits that this is what this case is all about. He says, our case extends to information that is not known, but is in fact an important part of assessing what the skilled person is already able to do, that which is in their repertoire already. And in saying that that was really what this case is all about, he's asking this court, for the reasons I've explained, to adopt a could approach because it was in their repertoire already, to use his words. And that is just a restatement of the could test that he put in proposition 3. He went on to say that we are trying to extend our case to, and I quote, empirical information which is part and parcel of carrying out the skilled person's repertoire. Again, this comes back firmly to just saying could is enough. And he stresses that we are seeking to exclude from consideration, and again I quote, information that is not known at the priority date but is routinely ascertained, not only using routine methods but using them for a routine purpose towards a routine end. We answer that by saying, as the judge did, that the issue of routineness is not sufficient, and on established case law he was correct to do so. It is just one of many factors in an appropriate case, as Lord Justice Kitchen himself explained in Medimune. And can I give the reference? It's MS 2074 in bundle 4, page 37. But it is no more than a potential factor. I'm told it's paragraph 91 to add that. In this case, the fact that the skilled person could do dosing studies does not mean that a dose that offers the technical benefits that is unexpected at the outset is obvious. In summary, none of my learned friend's propositions help in determining the statutory question, nor can they act as a shortcut to avoid asking and answering it. No, Glaxo didn't do dosing studies. He could do a dose ranging study. Could, but would he do it with any expectation of success of any particular claimed dose? Well, I'm going to come precisely to that point next, but it also brings into account what is the role of the technical effect of a surprising dose once found. Well, but based on the knowledge of Viagra and what was known in his common general knowledge, there would be doses that he would expect to be efficacious and safe, and those doses could well be obtained and marketed. Well, 25, no, as I say, as the judge found, with doses such as 25 milligrams, you would have satisfied the primary objective of the research product, which is to find a dose which is safe, marketable, and effective. So you do not have to go further than that in order to put Dogan into effect.
You accept that you would at least have to do enough work to identify 25.
That is likely to be done. But as the judge said, and I'll come specifically to the findings in that, but can I come back to that in just a moment? Can I turn to the cases cited by my friend in support of his proposition without turning them up? And these are just the cases in support of the proposition. My friend Mr. Mitchison will deal with those specifically referred to this morning. My friend's first case was Brugger and Medicaid. The reference was Authorities 2, tab 13, 1356. But if one looks at page 1356 and what Mr. Justice Laddie said, the proposition stated is circular. Mr. Justice Laddie said one trader should not be prevented from doing that which at the date of the patent was obvious. That, we submit, does not answer the question. The question remains, what is obvious that the skilled person should be stopped from doing, and that which is obvious? He then turned to Gillette, which is volume 3, tab 23, at 1643. And at 1642, line 10 to 1644, the whole question turned upon what the defendant had actually done was either old or obvious. And if what they had done was old or obvious, the defendant had the squeeze available to say, either I infringe and the patent is invalid, or I don't infringe and the patent is valid. Either way, you can't catch me. But again, to answer that question begs the question of what is old or obvious and hence unpatentable. So it doesn't take us anywhere, with great respect. My learned friend then came on to the three cases in the House of Lords, Merrilldow, Bargen and Synthon. Merrilldow and Synthon are firmly rooted in respect of novelty, and Bargen was concerned with sufficiency and scope of claim. Merrilldow was at Authorities 4, tab 38, and apart from being a novelty case, there are a number of reasons why it is of no assistance. First of all, it started with the infringement case that was dependent upon the inevitable metabolism of tefenadine in patients' livers, which gave rise to the intuitive response, which then had to be addressed. And then when addressing the implications of the patentee's arguments, all the examples given are so far removed from this case as to be unhelpful. First, at MS 2105, line 49, there's an epistemological discussion about what it is to know the same thing under a different name, and I stress the same. Hence the homely example about the rose-growing elderly gent. And that was to make the point that Lord Hoffman was making, that there are an infinite variety of descriptions under which the same thing, and again I stress the same thing, can be described. Hence telling the Amazonian Indian that their bark contains quinine adds no new relevant technical information, because they already knew that it treated fever, that which they called the spirit of the bark. And that is summed up in the case at MS 2106, at lines 38 to 48. And in summary, it has no bearing on the present case and discussion of obviousness, which will misguide and not inform the present considerations. As to Biogen, my learned friend relied upon this to submit that the concept of an enabling disclosure pervades all, and I quote, pervades all, including novelty and obviousness. Biogen was a sufficiency case where the question is whether the skilled person can put the disclosure of the patent into effect across its scope. But within sufficiency, the skilled person has the disclosure of the invention in their hands and is directed to work the claimed invention. The case does not address novelty or obviousness of the claimed invention at the priority date without prior knowledge of the invention. It does not assist. Finally, Synthon was firmly in the realms of lack of novelty, notwithstanding Lord Walker's remarks in that case, and for the reference, it's volume 5, tab 52. My learned friend says that this case is the most important of them all, but it's all about the concept of an enabling disclosure in the context of novelty, and doesn't assist on obviousness, as obviousness is not determined just by what is enabled or could be done. If it's his most important case, it's all the more surprising it wasn't cited before any judge below. Yet now, it is his most important case on his 7 propositions. My learned friend said that paragraph 63 of Lord Walker's judgment was, quote, absolutely key. That was at 114 of the transcript, and at 115 he said that Lord Walker says is another way of putting his big picture proposition that patent law is all about information that enables the skilled person to make products or processes. This comes back to his contention that what the skilled person could do is alone sufficient for obviousness. And for all the reasons we've explained, it's not. My learned friend wrapped up on the case law in support of his propositions in the transcript of page 116, line 25 to 117, line 21. He said, "We do not quarrel with the basic proposition that the basic and fundamental principle is the technical contribution must be commensurate with a monopoly. The technical contribution in this case is, as we have set out and the courts below have held and considered, the surprising result that doses as low as 5 milligrams are effective to treat erectile dysfunction with a corresponding technical effect that this efficacy has minimal side effects, notwithstanding its operation as a PDE5 inhibitor. That is a technical contribution. That is commensurate with the monopoly that is claimed in the claims of this patent. Can I sound another word of caution about the reliance being placed on novelty cases such as Merrill Dow and Synthon? And that is explained by the Vice-Chancellor, Sir Donald Nichols, as he then was, in the passage referred to in our reply case. It's paragraph 22 at MS 264, where he explains that it is important, and why it's important, to keep the two concepts distinct. Indeed, it would be quite extraordinary in our respectful submission if a case concerning novelty, and which has never been cited before or below in the context of obviousness, were used to support my learned friend's sweeping propositions. It is also extraordinary that my learned friend does not rely in support of his propositions on any established case law regarding obviousness, whether Medimune, whether Connor, or any of these cases. One can see why. Because Connor was a case at first instance of judging the obviousness of the claim by the way it had been arrived at. It was said that because it was obvious to see if Taxol might work on a stent, ergo the stent to treat restenosis was obvious. And there's a clear analogy with what is being asked in this case. Judging obviousness by reference to the way it was discovered and not by reference to the claimed outcome. Can I, as I said I would, return to my learned friend's response to my Lord Sumption, which is actually set out on page 120 of the transcript. My learned friend said it's not whether the thing, i.e. the claim itself, is surprising or unexpected. It is whether discovering it is obvious. But that moves the question away from the statutory question as to whether the claim is obvious to one, whether considering the matter by reference to the obviousness or otherwise of the research programme, and second, to get to an endpoint which is not the actual claim subject matter. And can I just again refer to paragraphs 8 and 31 of our case, at MS 138 and 143 as to why that approach is wrong. The same question was posed to my learned friend as to whether it mattered that one expects to find an optimal dosage and does not go further and show what the optimal dosage might be. And that's the case my Lord Sumption just put to me. That raises the issue of whether all unpredicted doses are patentable just because you can't give a precise value in advance. And that is not, and never has been, our case. If the technical effect is predictable, it doesn't matter if the number is 25 or 28.5. Both are obvious because they are unaccompanied by any different or unexpected technical effect. I stress again the significance of G208 in this context, and if that dose affords an unexpected technical effect, that is to be taken into account in the assessment of obviousness. The example of 25 milligrams as against 28.5 and not being able to predict a dose is like Lord Justice Jacobs' oft-cited example of the 5¼ inch plate. One can say at one level that it's not obvious because it's an unpredictable dimension. But the answer is that it solves no technical problem and therefore fails the obviousness test. But in fact, if miraculously I discover that a 5 7/8 inch plate will survive dropping from whatever height you drop it, then it is patentable because it has a surprising technical effect which is not provided or hinted at by the prior art. And that comes back to the beauty of the EPO's problem solution approach, by taking that technical effect into account. It's not to do per se with the predictability or otherwise of the value, it's to do with the beneficial technical effect. Turning then to the facts of this case, as my own friend did, he refers to the idealized dose response curve in his case at MS 208. And that's where you have a beautiful little area called the MED, the minimum effective dose. The first thing to note is that that curve is not in any evidence, nor indeed in the statement of facts and issues for that reason. It was generated for my own friend's case. The second thing to note is that even if the curves look like that, which they don't in practice, one cannot still just look at the region, which is the MED. On the evidence, life was not like that. And for that, can I just refer the court to the judgment of Mr. Justice Burse at paragraph 85 at MS 353, and also paragraphs 321 to 323 at MS 406 and 407. And he brings those factors to bear in his multifactorial assessment at paragraph 343.4 at MS 411. And all of that shows how far from the mark my own friend's illustration at MS 208 is. And it also explains to the court why so much of the judgment is directed towards the idea of this minimal effect, finding the minimal effective dose. And that you would find that the minimal effective dose was 5 milligrams, and therefore it was obvious, because that was his case at first instance. It was in the Court of Appeal that his case shifted to the idea that if the skilled person would do a dose response curve, ergo it would lead to 5 milligrams. Can I then turn to this morning's submissions as to when value judgments count? And can I just on this refer to paragraph 343.6, little Roman 6 of the judgment at MS 411. My own friend said the only ones that matter are those that are relevant as to whether the skilled person goes into the claim. But you cannot ignore the value judgments that need to be made on the way. It's part of the multifactorial assessment that the learned judge carried out. And for the reasons I've been over, that is the case. My Lord Hodge pointed to the fact that ultimately pinning down the dose response curve, the end of the dose response curve, wasn't in the statement of facts and issues. All the judge said was that the idea of phase 2B was to show an effective dose. And can I just give the references here and ask the court to see what Mr. Justice Burse held on this, on the facts. The idea of phase 2B is paragraph 78 at MS 352. I'd ask the court to look at paragraph 85 afraid I don't have an MS reference for 85, but that'll be given to me in just a moment. And to paragraph 327, which is the last sentence. The end of this section from my learned friend Mr. Speck ended with the statement that, and this is crucial, he said, arriving at, for the reasons that he gives with the dose response curve, arriving at 5 milligrams is well within the skilled person's repertoire. His case again comes no more down to what they could do. My learned friend sought to refer to the Dogan patent, Appendix Part 2, MS 598. It doesn't assist. In fact, it throws up the problems associated with my learned friend's point. There are two compounds there, the compounds A and B, one's tadalafil, one's another drug. There is or are no dosing data whatsoever. And my Lord Sumption said if routine, more than routine would have been required, then the patent would be insufficient. Well, no, because higher doses, such as 50 and 25, would not be considered insufficient. 50, for example, is specifically disclosed. Well, Lord, it illustrates, in fact, why improvement patents have to have room to breathe. My own friend then went to the timescale, and he referred to the document seeking permission to appeal, referred specifically to 11 to 18, and also made the point that much the same is said in our case on the chronology. He said it's the same in paragraph 48 to 56 of our case at 148 to 149. He asked the question rhetorically of me, why is it legitimate? And the answer was actually answered by my Lord Sumption on the date of the filing of the priority document, because before going into phase 3, you need to have your patent filed because you are done down by what's as part of the state of the art. The larger scale phase 3 clinical studies are notoriously leaky as a matter of confidentiality. So if you don't put the priority document in and then do the phase 3 clinical studies, you're then rendered lacking novelty or obviousness because somebody has disclosed the existence of the phase 3 clinical study, which have to be done on a worldwide basis, as was the case here. What justification, my own friend said, could there be for this situation? The situation is that Lilly conducted 5 years of clinical research. And what they have, as a consequence of that, having discovered the surprising technical effect, is a 2.5-year additional monopoly over the SPC for the basic compound. That is entirely in keeping with the policy and operation of the patent system. We're not getting another 25 years. We're getting a monopoly that is entirely commensurate with our technical contribution. And just to give the reference of my Lord Sumption in Warner Lambert, it was paragraph 29 on page 17 of the Supplementary Authorities Bundle. That's why the chronology as it is. But it doesn't undermine in any sense whatsoever the fact that we did the additional phase 3 studies. There is no, quote, timing problem that my learned friend says. The policy is that we had to put the priority document in. The priority document with all the passages does support the surprising discovery, and it was then fleshed out with additional information which is not added matter. My learned friend then sought to draw a distinction between is it an improvement case or is it just an empirical filling in the gaps case? And again, you're starting to discriminate here. If in fact you've made an invention, trying to then discriminate in this way is going to lead to all sorts of problems and difficulties. Is it a different lines of inquiry case, or is it a feedback loop case? Well, these may or may not be relevant factors in the multifactorial assessment, but we can't approach the law by seeking to divvy it up in that way. He says empirical implementation is not empirical research. Well, how are we to decide? Where's all this going to come from? And then he gave his antibiotic on the beach point. My own friend Mr. Mitchison's going to briefly address the case law, so I'll skip over what was then said. After KCI, he came to the fact that, well, we can prove the point by reference to the formulation in the 092 patent, which was held obvious over Dogan. Well, yes, it was, and it proves the point, because there was no associated technical effect there that we, on the evidence, could point to. Nothing unexpected, nothing surprising. And that just shows how fair the judge was being. That patent was held to be obvious, but the dosing regime was held not to be. Finally, then he came to policy, and then the SPC system. And the fact is, the SPC does not apply to new inventions, and it's not relevant to the questions of law that this case raises. The EPO approach, then, again, I'll leave my learned friend Mr. Mitchison to address. And the foreign decisions. Germany, he focused on. No attempt to grapple with the EPO's problem-solution approach. My learned friend Mr. Mitchison has will address how the bonus effect is applied here and in the EPO. And it's to misstate the findings. If one looks at the paragraph to which he referred on page MS 3134, in fact, the findings were not as Mr. Justice Burse had found them. Yes, Australia is different, but it's important to see, therefore, they also have an expectation of success in a very similar way to the EPO does. Respondent's notice I can deal with as briefly as my learned friend. He said 3 reasons. This case raises a symmetry regarding enablement. Well, that doesn't help him in any respect. He says the test applied by the court was the wrong test. With great respect, it satisfies my Lord Sumption's approach for all the reasons I mentioned in opening. There's no difference post-Warner-Lambert. When one looks at those paragraphs of the Court of Appeal, they were plainly not adopting, Lord Justice Kitchen was not adopting a minimalist approach, and everything he said about molecular mechanism and an explanation, a rational reason, all applies to the reasoning of Lord Justice Kitchen. And also, I would just make this forensic point, but it's not unimportant. This is a little bit opportunist because they never actually pleaded a lack of plausibility case. What they had done in Warner-Lambert as regards priority, it was all done on the basis of disclosure so far as priority was concerned. There was a squeeze with Stoner. Yeah. In this case, it was all about disclosure, and the contrast with Warner-Lambert is stark. And just to get that, for the reference, it comes out of paragraph 41 of Mr. Justice Arnold's decision in what is called the abuse judgment at 2015 EWHC 3370 at 40 to 41, where the same parties, Actavis, Teva and Milan, had pleaded a specific plausibility attack on as a matter of insufficiency. And Mr. Justice Arnold, the paragraph 41, said it was clear from the pleading was being alleged the claims were implausible in relation to types of pain for which the 3 animals were used to generate. There's nothing here. And actually, when you look at the judgments below, they're very much directed at the arguments that were being raised. But as I say, those paragraphs of the Court of Appeal, where we have, obviously, concurrent findings, manifestly meet the Warner-Lambert test. And third point was that our case on inventive step was different on obviousness and butts up against plausibility. I explained why that is not so in opening. I showed the court the relevant passages of the priority document in opening, and they are more than sufficient for the reasons expressed in paragraph 83 of Lord Justice Kitchen's judgment at MS 305. That leaves my learned friend, I think, enough time, and if there's any time left at the end and someone tugs me hard, I might come back. But at the moment, I think I've dealt with everything, quite a canter, but with enough time for my learned friend to deal with the cases.
Thank you, Mr. Orr. Thank you.
A lady, my lords, if I can deal with the cases referred to by my learned friend Mr. Speck this morning in the order he did. Firstly, he referred to Hallen and Brabantia by reference to page MS 3597. That's the Terrell extract. And there's nothing in that case which contradicts the principle that I explained yesterday. If the court would go to, that doesn't need to go to now, but if the court would note page MS 1666, which is the decision of the judge in Hallen and Brabantia, he pointed out there that there was a beneficial technical effect expected by applying PTFE to the corkscrew. That was to put the corkscrew into the cork, and the fact that there was a second technical effect of lifting the cork out of the bottle couldn't save the claim. But there are two technical effects there, one of which was obvious, and we contrast that with the present case before you, where there is no technical effect that is obvious at the priority date. The next case my learned friend took you to was Brugger and Medicaid, MS 1356, where the judge there said there may be more than one obvious route. That might be, but there still needs to be an expectation of success to get there. And so again, as my learned friend has already submitted, this is really a circular point as far as my learned friend Mr. Speck is concerned. You still need to judge obviousness by reference to the statutory question and applying, if necessary, the expectation of success factors. The next set of cases my learned friend Mr. Speck took you to were Technograph, Connor, Gideon Richter, and he tried to suggest that the principle set out by Lord Diplock in Technograph was only very limited to the facts of that case where there had been a line of cross-examination and no expert on the other side. With the greatest respect, the principle is of much more general application than my learned friend Mr. Speck would suggest, which is why it has been referred to in so many cases since Technograph was handed down. And the reason is because there is always a danger of hindsight in any patent case, because by its nature you are trying to examine the question of inventive step after the event. And Lord Diplock's warning is to try to avoid the application of hindsight and ask the question whether you would perceive the final result, which it was the object of the inventor to achieve, whether that was attainable from the particular starting point. And as I explained yesterday, that's absolutely in line with the European Patent Office. And so you have to have the target of the claim in your mind, that is Connor. It's not something less than is in the claim, some vague paraphrase. And we respectfully submit that my learned friend's attempt to say, oh, well, you're just looking for a fixed dose response, or even, he said at one stage, just to implement Dogan, that is precisely the vague paraphrase which Lord Hoffman explains in Connor should be avoided, and my learned friend doesn't grapple with the expectation that the skilled person would have of getting to 5 milligrams with all the benefits that that entails, as we have already explained. And so Gideon Richter, which really deals with the same point as the Technograph point, the hindsight point, it is dangerous if the only thing that the court does is look at each putative test and decide whether or not that was obvious. And Lord Justice Floyd recognised that in Gideon Richter, and he says you do need to stand back and look at the overall question of obviousness of what's in the claim at the priority date without the benefit of hindsight. And that's where we say the principle in Gideon Richter can be taken too far, and that's the mistake that the Court of Appeal made in the present case. So it is permissible to take account of putative proposed experiments at the priority date, but there is a limit. There still needs to be the overall expectation of success, and the technical effect embodied in the claim has to be predictable. And if you only look at each individual step on its own, that is the best example of hindsight coming into the analysis. And both the case law in the EPO and in this jurisdiction are replete with examples of courts warning hindsight has to be excluded, and that the test has to be the test carried out at the priority date without the benefit of knowledge of the invention. Finally, on the domestic law, my learned friend took you to Actavis and Merck and tried to use paragraph 32 of that to suggest that really no dosage regime cases should be patentable. We respond that there is an unexpected technical effect in this case, which is unusual and makes this case of a dosage regime different to the usual case where, as my learned friend Mr. Waugh explained, you're looking for an appropriate dose and it's either 25 or 25.8. It doesn't matter which it is, and it doesn't matter if you can't predict that in advance. That is to be distinguished from the present case where there is a separate and distinct and unpredictable technical effect of getting to 5 milligrams with the low side effects and the efficacy at that level, and that the skilled person would not have expected, as the judge found, and that is why this claim is to be distinguished from most dosage regime cases where there is no additional technical effect. Next, I come to the European Patent Office cases. My learned friend had 3 propositions and referred to 4 cases. His propositions were, you have to get to something within the claim. Well, that's accepted, that if part of the claim is obvious, then it's all bad. Secondly, he said a stepwise approach is sometimes okay. And thirdly, he said that the European Patent Office can take account of routine steps. Those principles may be sound under the overall heading that there still has to be an expectation of success, and you have to assess what is in the claim by reference to the new technical effect caused by the said feature. So ultimately, you always have to ask the question, would the skilled person have suggested the claimed technical features in order to obtain the results achieved by the claim invention? Sometimes that may take account of routine or stepwise approaches, but you still have to have the overall question asked and answered. And for the reasons I gave yesterday, it would be answered in the negative in this case, and this claim would be found valid by the highest courts in the EPO. And so the particular cases my learned friend took you to, or referred you to, he referred you to case T936 of 96, on page MS 2825 for the bonus effect principle, but that's entirely in line with Hallonen and Brabantio, and all that case set out was that if there was an additional problem that had been solved, if the first problem was, the skilled person would be expected to solve it, the fact that there was an additional problem also solved doesn't assist, and that is entirely in line with Hallonen and Brabantio. Next, my learned friend came to the Welcome case, which I relied on yesterday. He couldn't really explain it away. And we say that his failure to do so and his failure to address G2 of 08 at all with the court is really very surprising and undermines his case significantly. In particular, I only relied on Welcome as an example of a case, and the authority I rely on is G2 of 08, which is the highest court in the EPO, which explains that the problem-solution approach must be adopted, and Welcome is a good example of that, where the TBA identified an unexpected as well as an advantageous result, justifying a finding of inventive step. And we say it is astounding that, given there are 37,000 technical Board of Appeal cases having been issued by the EPO in its almost 40 years, not a single case has been cited by my learned friend with an example of a dosage regime which has been found to be obvious based on the principles he outlines. And so we say all of the authority on dosage regime cases, including from the highest court, is in our favour. Finally, my learned friend referred to the guidelines on page MS 3566 in relation to the stepwise approach. With the greatest respect, you need to read the previous paragraph to the one he took you to, which makes clear that the problem-solution approach and the technical effect still needs to be expected. Then he referred you to the laser printer case, T558 of 00, which is referred to in his case. That was a stepwise approach, but the overall effect was expected. The skilled person would expect to get the laser printer to work, and so the fact it took 2 or 3 steps to do so doesn't undermine our case whatsoever. Finally, he referred to the Hep B case, 886 of 91, and we say, in fact, that supports our approach and doesn't undermine it. If you look at the passage on page MS 2735, you'll see that the first claim that was sought it was held that the skilled person would expect to be able to perform, get to the claim with a reasonable expectation of success. They would expect to be able to sequence the DNA as a whole, and there was no new technical effect added. But the second claim, which the Technical Board of Appeal then went on to deal with, page MS 2739 to 2740, that was to excerpts of the DNA, and the TBA found that there was no expectation that the skilled person would be able to successfully separate these excerpts, the eukaryotic genes, from the prokaryotic host because of the presence of introns. And they said expressly that it wasn't predictable, and it was only with the benefit of hindsight that it is now possible to follow the specific route, and there was nothing in the prior art that would have suggested this route. So that is a classic application of the problem solution approach, where there was no expectation of success of reaching the technical effect and benefit in the claim, and the application of hindsight was deprecated by the Technical Board of Appeal. And so, my lady, my lords, we say that all of the case law in the EPO supports our approach. It is, my learned friend has no explanation for the application of G2008, which is the leading case. He cannot explain that away, and combined with the conventional approach in the United Kingdom, we say that our approach is to be preferred, and this patent should be upheld as being non-obvious and inventive. Unless I can help the court any further, those are my submissions.
Would appear not, Mr. Mitchison. Thank you very much indeed. You've got a few minutes if you'd like to come back, Mr. Oh, you of course, have got to answer.
10 minutes. Yes. I'm not going to take 7.
Sorry?
He was allocated.
Yes, but he went over his time, so.
Have I? Right. Well, don't worry. I'm going to be very short. I think I had 10 minutes allocated, but I'm going to be 5. The first point is I specifically disclaimed saying that by repertoire I just meant something that was within our technical capabilities and that the methods were available.
Aren't you supposed to be replying to their answers to your respondent's notice, rather than to what they say about your case?
That may be true. That may be true, and I apologise for that. There is one point that I do ask my lady to allow me to answer, because it's a misrepresentation of something about what I put in my case, and it's basically a suggestion that the drawing of the curve isn't in the evidence. That drawing reproduces what was in the evidence, and I can show my lady that. It's MS page 808, and it was a textbook that I cross-examined Dr. Saoud on, and the cross-examination is also in your bundle at MS 862. The purpose of putting it in a neat drawing is to show the relationship between the dose response and the MED. Now that relationship isn't in the evidence, but the point that I'm making about what the dose response is, and it's in those pages. That's it then, if I'm limited like that. Unless you have any questions for me on the respondent's notice.
I think we're all questioned out. Thank you. Well, thank you all very much indeed. Clearly the answer is not obvious. You'll have to go away and try and work out what it is. So we'll let you know in the usual way. Thank you.